defendant's existing bond be continued. That's $10,000 cash surety, 10%, and with the condition that there are no drugs and alcohol.
Mr. Paris.
Good morning, Your Honor.
Morning.
John Paris on behalf of Mr. Ashante Barron. Your Honor, he's in receipt of his indictment. He'd waived the reading of the entire indictment in open court, enter a plea of not guilty, and asked that the bond be continued. He has also executed the waiver of speedy trial as well as the bond condition document.
All right, not guilty plea will be entered. Bond will be continued at $10,000 cash surety or 10%, with condition of no drugs or alcohol. Any further?
Not from the state, Your Honor.
No, Your Honor.
All right.
Thank you.
All right.
luck today.
Thank you. Yeah,
Cool.
back to Condon's room. Yeah. He's giving us both hard times.
At least it's, you know.
Yeah, he's
Plea to those allegations,
Guilty.
accept your guilty plea and find you guilty, what's the problem? What's the problem?
I fucked up.
I know you fucked up, okay? I know that, that's why you're here. That's not my question. My question is, what's the problem?
There's no problem really.
There's no, then, if there's no problem, why are you using cocaine?
I mean, I don't know.
You don't know.
I just had a lot going on at the time, so.
All right, and cocaine solves the problem.
No, it don't.
Where'd you get the cocaine?
I got it from some guy at work, but he don't work there no more, so.
Boy, why did he get fired?
He quit. He got another job, so.
Am I to understand you just got your kids, custody of your kids, and you're out using cocaine?
I didn't get him. My sister has them right now. They told me I wasn't allowed to have them because of my record. And the lady just came and talked to me yesterday.
What lady?
The caseworker through for JFS.
When it, is this gonna go on the rest of your life? What's the story?
For what?
What? This!
Oh.
Is this gonna keep going on the rest of your life?
No, sir.
When's it gonna stop?
It stopped as soon as I was done the last time. I'm done. As soon.
Well, it stopped last time, but why are you here again if it stopped last time?
I'm saying that the last time I did it was the last time I did it. So.
Right, December 29th. Right?
Yes.
So you're not gonna do it anymore?
No, sir.
How are you gonna manage that?
Well, I was gonna continue with aftercare or IOP and do counseling and.
Didn't you go through the jail treatment program?
Yes,
And what did you do after you completed the jail treatment program?
I was in aftercare.
That didn't solve the problem. While you were in aftercare, you're using.
Yes.
So why now all of a sudden, if you go in aftercare, is that gonna solve the problem?
I mean, it's gonna help me more if I go to IOP, because they do random drug tests, and you go 3 times a week.
Well, Kim does random drug tests, and you were using. What do random drug tests have to do with it?
I mean, they do it every week though, and it's out of the 3 days it's random, so you don't know which of the 3 days that when you go, you do it. So that's gonna help out a lot more too.
So your excuse for using, as I've been told, you didn't tell me this, but other people told me this, is you use cocaine because you need energy.
What?
What?
Who told you that?
I don't know. Who told me that?
I did,
Why'd you tell me that, Kim?
because that's what he told me.
Did you tell Kim that?
I mean, I might have, but
You might have. Did you or didn't you?
I probably did, yeah.
Okay,
I
then
don't
why are you
remember
asking me
saying
who told you that? When
I
you
don't
told-
remember saying it, that's why I was confused.
So, did you use cocaine because it gave you energy?
I mean, yeah,
Okay.
I've been tired, you know, trying to deal with helping my sister with the kids and working a lot, so
Well, whose responsibility is that?
mine,
Okay. So what are you complaining about?
I'm not.
Yeah, you are. So you mean that you gotta watch your kids and you gotta work?
Well, no, I don't gotta watch my kids. I'm not allowed, you know, I help my sister out with
How
all
do you
her
help your
kids, her
sister?
my nieces and nephews and everything.
How do you help your sister?
I watch them all while she goes to work, and then I gotta get a babysitter so I could go to work.
You babysit her kids?
Yeah,
What about your kids?
I have my kids they're there too. I don't babysit them because they're my kids, but they're, and they're my nieces and nephews too. I don't, I just watch them.
So
Babysit.
you gotta work, you gotta take care of kids, and so you're tired. Right?
Yeah,
Welcome to everyday life that everybody has. So, Kim, how long you been working at the probation department?
13 years now.
Where'd you work before that?
Lake Erie Correctional Institution.
How long were you there?
4 years.
Okay. Did you have kids?
I did.
All right. Did you have to take care of your kids?
I did.
Okay.
Yes.
And you had to work?
I had to work, yes.
Imagine that. So it doesn't sound like the excuse of I'm tired is gonna stop. You seem a little bit irritated about being here today,
no,
about answering my questions.
no.
I can't change you. Kim can't change you, Nicole can't change you. If you wanna live like a malcontent, then live as a malcontent. If you want to live like a regular person, staying out of jail, then live like a regular person and stay out of jail. Go to work, meet your obligations every day. Or not. I don't care. I don't change what you do. I just clean up the mess that you make. When do you work?
I work, well, I'm starting 6 days a week. There's only 3 of us that work there. My brother full-time, I'm full-time, and then the other guy's part-time because he works another full-time job.
When were you supposed to work in the last 4 days?
Tuesday, Wednesday, and maybe today.
Do they
Might
know
have
where
to
you
work.
are?
Huh?
Do they know where you are?
Yes.
Did you get your license yet?
Not yet.
Why not?
I asked my mom to put me on her SR22 bond, and she told me to wait till the beginning of this year till her insurance restarted for the whole 6 months. So that's what I was waiting for, because it was cheaper to go on hers instead of getting my own and I have to pay like $400 a month. I'll pay like $234 or something, $243. I think she said it was a month for me to be added on there.
Oof. How much money you make at your job?
I'll be making I'll be salary now, so I think he said $13.50 every 2 weeks
Okay.
since I'll be
Stop.
salary.
Stop spending money on cocaine. You'll have money for insurance.
Yes, sir.
All right, I'm gonna keep you on community control, 4 days, credit for 4, an IOP with Lake Geogga, and follow all the recommendations and everything else I told you to do back on August 20th.
Okay.
Now, get your ass out of jail, get back to work, and meet your obligations
All right. Thank you, sir.
without the cocaine.
I will. Thank you. All right.
Do you want to see him today?
I know. I come right through.
older ones,
Yes.
and then he's, just last two are younger. To change his speech pattern. It sounds like a
Go want to represent yourself?
I can't do that, sir.
All right, so tell me what your condition is right now.
I'm pretty much blind in my right eye all the way. I can't hardly hear out of my right ear. And my feeling in my right arm is starting to come back now.
All right, how does it affect your capacity to understand things and process your thoughts?
I talked to my wife about my two children, and I don't remember very much about them.
Okay,
But, you know, I don't want to roll this on as long as you guys don't either. You know, I want to just get it over with as soon as possible.
all right. Do you, there are two counts against you of both felony 5 aggravated possession of drugs. They've come from February 11th of last year. Do you remember those offenses?
From what I've been reading about it, yes.
Do you remember them independently of reading about them?
Do you remember them independently from reading about them?
What's that mean?
Do you remember them without reading about it?
I mean, just,
To be honest, do you remember the offenses? Would you remember them if you hadn't read about them?
no.
How long has he been in jail? Since,
I don't remember. I got here like 3 or 4 months ago.
okay, so you were in Lorraine Correctional then, right?
You were non-correctional.
Yes.
Okay. How long is your sentence there?
I go home in May, don't I?
Mm-hmm.
I go home in May, sir.
Okay.
I think it's the end of May sometime.
When did he get there? Do you know?
To Lorraine Correctional? No, I do not know.
I presume it was sometime after February 11th.
Correct, I believe that he was violated by the parole board based on this, not even on this case, a separate issue.
Do you know?
And we conveyed him here for arraignment.
I don't know the exact date, Your Honor. I know he was sentenced to 9 months.
On a violation?
On a violation not pertaining to this case, a different violation.
Oh, okay.
I've been trying to contact his parole officer to get the exact violation. I've not had any success.
All right.
I took.
Are you having overall problems with your memory or not?
That's what my biggest issue is, they're saying.
When's the last time you saw a doctor about this condition?
According to, that's what my issue is with the jail right now. I just went to see the doctor in the jail, I think I told you or my wife. Last week, I went and seen the doctor, and she told me I won't be on the list to go out and see a specialist for 2 or 3 months from now.
Are you going to file a motion to deal with the competency? Because it seems to me that if he's representing to me right now that he's got memory problems to the extent he doesn't know his kids' names, that would be an issue of whether he could, and he doesn't have independent recollection of the offenses. If that's accurate, then that would indicate that he may not have the ability to assist in his defense.
Yes, that was the plan, Your Honor. I just was waiting to see what was happening today prior to filing that competency, but I will get it filed today.
Go ahead.
I understand. I don't want to be in here no more.
Okay.
I-
Well,
I'll accept what you give me. I don't wanna be here no more.
Well, I can't give you anything until I find out if you're even competent at this point because of the stroke. So get that filed. We'll try to move this as quickly as we can to make a determination to resolve this thing. Anything else from the state?
Nothing further, Your Honor.
Okay, Nicole or Nicolette, get that thing filed, okay?
Yep, I will. Thank you.
All right.
Okay. Okay. I'll keep you updated.
I'm gonna wait outside, cause I have to go back and forth. I'm gonna wait outside,
Okay,
at, prosecute council, so it's time to get that,
Okay.
back and forth to the bathroom.
Okay,
so
okay.
it's-
nice to meet you, sir. You know when the judge comes out, stand up. Where you working? Okay, I need to tell me this. I don't have your home address here.
All rise.
Seated. Mr. Geigerich.
Thank you, Your Honor. Before you today on State versus Emmanuel Silliman, file 25 CR 1682. We're here today for a pretrial. Discuss the matter with Mr. Goldberg, and it appears we have some kind of issue with the portal, which I'll rectify upon my return to the office. Other than that, State of Ohio is prepared to go forward.
What's the offer?
There is no offer at this point, Your Honor.
So it's plea to the indictment?
That we haven't even discussed any kind of a,
Mr. Goldberg?
That's correct, Your Honor. We filed discovery, and I take Mr. Geigerich's word that there's some kind of snafu. But we get that discovery, I'll review it quickly with my client, and we will start talking about resolution.
Okay, I'm gonna set this case for a jury trial on March 16th at 8 a.m. And then we're gonna set another hearing that'll take place March 4th at 8:30 a.m. And that will be the opportunity, Mr. Silman, for you to either accept the offer, whatever it is, or reject the offer. Do you understand that?
Yeah.
If you reject it, then we'll proceed to trial on the 16th. Anything else, Mr. Geigerich?
nothing, Your Honor, thank you.
Mr. Goldberg?
No, Your Honor, thank you very much.
All right, we're adjourned.
You know, the only
You're welcome.
So, I guess you don't make that right.
Entry report, drug and alcohol evaluation, and victim impact statement may be completed. There's no sentencing agreement, and that is the state's understanding at this time. Thank you.
Ms. Novotny?
Your Honor, at this time, before coming into court today, we went over the written plea of guilty as well as the waiver of indictment. Mr. Hensley would like to accept the state's offer with that case and plead guilty. And at the end of the hearing, we would like to discuss bond with the court as well.
Mr. Hensley, how old are you?
47,
How far did you go through school?
10th grade,
Are you a U.S. citizen?
yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
Have you ever been diagnosed with or treated for any mental illness?
nope,
Did you get a copy of this information?
yes,
Do you understand you have a right to have your case submitted to the Lake County Grand Jury for them to decide whether or not to indict you?
yes,
Did you discuss that right with your attorney?
yes,
Are you going to waive that right?
yes,
Your Honor, in open court, myself and my client signed the waiver of indictment and passed it to the prosecutor to witness the same.
Your Honor, I've received the waiver of indictment. I witnessed the defendant sign the document in open court. His counsel signed it, and I have signed it.
All right, I'll accept the waiver of indictment. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk some more to Ms. Novotny, let me know, and I'll give you more time. Do you understand that?
yes,
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
yes,
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes,
Do you have any questions about any of these rights?
nope,
You still want to plead guilty to this charge?
yes,
You understand by pleading guilty, you're fully admitting your guilt to the charge.
yes,
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
yes,
Violating a protection order is a felony 5 that carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand that if a prison term is imposed in this case, you may have to serve a period of post-release control as part of the sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. You understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence would be the greater of 12 months at the time left under post-release control. Do you understand that?
Yes.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. You understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
Nope.
Has anybody promised you what I will sentence you to, not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Ms. Novotny before pleading guilty to everything about your case and answered all of your questions?
Yes.
Have you?
Yes.
Have you been threatened or coerced in any way to plead guilty, knowingly and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
Nope.
Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 10th of 2025, shortly after 2 a.m., Wickliffe Police Department officers were dispatched to the Plaza Motel on Euclid Avenue in Wickliffe, Lake County, Ohio, to speak with Jennifer Chinchar regarding a protection order she had against Christopher Hensley, the defendant. On December 2nd of 2025, Ms. Chinchar had filed for and was granted an ex parte civil stalking protection order under revised code 2903.214 in Lake County Court of Common Pleas 25 CS 002232. Defendant was served with that ex parte protection order as well as with the final hearing date. He was served on December 3rd of 2025 by personal service. The final hearing was scheduled for December 9th of 2025. It did go forward. The defendant did not appear. The protection order was granted on December 10th of 2025 to be in place for a year. When the officers arrived on December 10th, 2025 and spoke with Jennifer Chinchar, they learned that the defendant had been calling and texting her since about 1:40 a.m. He was calling and texting, requesting information about whether she went to court that day or not, which was regarding the final hearing of the protection order. She either spoke to him or he left voice messages, so she was able to hear that it was in fact his voice, as well as he was referring to something he would specifically know. While the officers were there, the defendant called. Ms. Chinchar answered the call on speakerphone so that the officers could hear. He identified himself, indicating that it was in fact Chris, and he was asking her about if she went to court. She indicated, as well as law enforcement, that he is not to be in contact with her. These calls were about 10 texts and 6 calls from between 1:40 a.m. and 3:08 p.m. throughout the day, even after the police left. The defendant does have a prior conviction for violating a protection order under 2919-27 out of the Willoughby Municipal Court in case number 22 CRB 02392, dated November 1st of 2022. It was the same victim in that case, and that all of this occurring in Lake County, Ohio, and that would have been the state's evidence. Thank you.
Thank you. Ms. Novotny, anything to add to those facts?
No, Your Honor.
Mr. Hensley, did you hear what Ms. Cutts said? The facts would show if the case went to trial.
Wait, what'd you say?
Did you hear Ms. Cutts?
Yeah.
The case went to trial.
Yes.
Are those facts true?
Yeah.
What is your plea to violating a protection order, a felony 5?
Guilty.
Ms. Novotny?
Remember this document. Sign date. Today is 1/15/26. Your Honor, in open court, myself and my client signed the written plea of guilty paperwork and passed it to the prosecutor to witness the same.
Your Honor, proceed the written plea of guilty and judgment entry. A witness for the defendant signed the document of the court. His counsel signed it and I signed it.
Mr. Hensley, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Ms. Novotny advised of all of its rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty.
Yes.
Finding it to be knowing, intelligent, and voluntary, I will accept his plea of guilty and find him guilty of violating a protection order of felony 5. I'm going to refer this for an updated pre-sentence report. Sentencing will be February 13 at 11 a.m. Ms. Novotny.
Your Honor, we would like the court to consider a bond modification, specifically if the court would be inclined to consider an own recognizance bond for Mr. Hensley. Mr. Hensley informs me that he would reside at 28439 Evergreen Drive in Willoughby Hills. He lives there with his mother, who is 92 years old, and he is the primary caregiver for her. Helps her with everyday functions and living, does housework for around her and maintenance. He also helps maintenance along with neighbors on his street that are elderly with regard to anything revolving the house. Your Honor, he also works, from my understanding, for Best Asphalt. He's been there on and off for 15 years. I know recently he's had some medical issues with intestine surgery. Previously in June 2025 he had it, in September of 2025 as well for a follow-up, and he is seeking medical attention as well. I know he's been having problems and complications for where that surgery has been occurred. Your Honor, we're just asking for any type of leniency when it comes to bond today.
Ms.
Thank
Cutts?
you.
Your Honor, when this agreement was made, there was no talk of changing bonds. We were not anticipating a request for this. However, we do feel that it would be inappropriate. The defendant continued to call and violate this protection order for the entire day. He did admit when he was arrested by the police that he had been served with the protection order and that he knew he was not to be contacting her. He disregarded that. In Willoughby Municipal Court, he was told that he was only to make phone calls to his lawyer from the jail. He has been making phone calls to other individuals as well, so he did not listen to what that judge said either. He does have a criminal history that includes 2 prior prison terms on 5 cases. All of those cases were before Your Honor, and he was sent to prison in 2021 for possession of drugs, 2 different cases, F5s, as well as an F5 theft in a 3rd case. And then he was sent back to prison in 2023 by this court on 2 different cases. One in this court, an F5 possession of drugs, and a Cuyahoga County F5 possession of drugs. He got out in 2024. Ms. Chinchar has indicated that there have been other protection orders that he has violated. We know that from his prior as well. So based on his history, how he handled this matter, we would ask that his bond at a minimum remain where it is, if not be increased or revoked.
All right, I'm going to revoke the bond. Anything else?
No, Your Honor.
Your Honor, the victim impact statement also be ordered.
So you do that on February 13th at 11.
Doesn't have a bond, don't get out of
You
this?
don't have a bond, no.
any doubt that you warned them of all of that. Especially
with regard to expert reports after that, and the other dates remain the same. So now, here we are with problems everywhere. And so what's the problem?
Good morning, Your Honor. Christine Garitano for the plaintiff. I appreciate you entertaining the parties on short notice on these issues. From the plaintiff's perspective, there are three main issues. There may be others that others have, but from the plaintiff's perspective, the issues that we have are threefold, all related to depositions that have been noticed and the scheduling of those depositions. The first relates to a notice of deposition for a representative of defendant AECOM. That deposition was noticed in late December. Defendant's counsel indicated that it had some objections and asked for a meet and confer. We did do the meet and confer. As a result of the meet and confer, I attempted to address many, but not all of the issues raised by AECOM's counsel. I believe at that time we were still on an impasse at 9 of the 31 categories requested in that deposition notice. However, for the remainder, I did make some attempts based on our discussion to modify some of those. Amended notice of deposition was issued the following day. We received late yesterday new objections to the amended notice. I believe now the amended notice, by the way, eliminated a couple of categories, so there were 29 distinct topics.
Which 9 remained outstanding?
The 9 that remain outstanding are presently after the latest round of objections.
Well, before you tell me that, which 2 were eliminated from the original 31?
The 2 that were eliminated are all documents produced by AECOM, which was originally number 26. That's been eliminated entirely. And I'm sorry, I did a compare red line, so I'm looking at that. The last one originally was 31, which was AECOM's discovery responses. I eliminated those in their entirety.
Okay, so all but 9 have been agreed upon? Is that what you said earlier?
No, we were at an impasse at that point after the meet and confer, except with respect to 9 of those. After I revised and narrowed the scope of some of them, we are now at an impasse at apparently 12 of the 29 categories.
So you were at 9, you revised it, now you're at 12.
Well, to be fair, after the meet and confer, I revised them. He had to go back to his client to, consult with them.
Okay.
And after that, there were still some that they refused to produce witnesses on. So that's that initial issue.
Okay.
The second issue is I noticed a fact witness employee of defendant AECOM, Vikram Gautam. He is a geotechnical engineer on the project based on discovery.
You say he was on the project. They say he was not on the project. He had nothing to do with the project.
Yeah. Well, Your Honor, I didn't know until they produced documents that imply or suggest that in fact he was specifically consulted about the use of the shale fill material when it was being proposed. Now, I understand, based on our meet and confer, that his intention is to say that he doesn't remember that. Well, that's fine, if that's his answer, but I believe I'm entitled to cross-examine him on that. So that's with respect to the project. He was also consulted later when AECom was investigating what the issue was. He was consulted at that time too. Again, the documents indicate that. So that's another issue I think I'm entitled to talk to him about. I believe I'm also entitled to talk to him about his general knowledge, understanding, experience, and expertise as a geotechnical engineer with respect to this use of this material in general.
If he was involved in the project?
Whether,
Or if one of those two factors, either when the problems arose initially, and you raised that to AECom, if he then reviewed things, so is it one of those two hooks that he would be able to talk about that in general? Or just
Correct.
as a guy who knows this stuff, or
That's
may or may
right.
not know? Okay, is one of those two hooks, right?
that's right, Your Honor.
Okay.
It's plaintiff's position that AECom sold this project to my client on using its vast knowledge and expertise in every specialty. And therefore, I think that we are entitled to explore, you know, whether or not they did that. We know that actually they did, and what that knowledge and expertise was, and why they didn't use it in this case, apparently.
Okay.
So that is the second issue. The third issue is just the general order and scheduling of depositions. No one had noticed depositions in this case before I did so in December. I noticed those and requested that they be provided in a particular order based on plaintiff's strategy in this case. I believe I'm entitled to do that. Approximately a week later, defendant AECom issued its own deposition notices, which is fine. I don't object to any of those, including the 30B5 categories that they gave me, which are very similar to the ones they're objecting to in mine, but my clients don't have anything to hide. But given this dispute with respect to these two issues, I don't believe they should be able to take the depositions that they requested of mine because they manufactured a discovery dispute, you know, so they could go first. I think it's common practice, and if everybody's being honest, if you notice depositions first, you get your witnesses first. That's just the way it goes. And so, you know, until we can, you know, agree on the depositions that I've asked to take, I don't think I should have to produce my witnesses. Now, I did offer to schedule them all, including mine, in the order that I requested off of the bat, you know, and then deal with these discovery disputes. And if we could get them resolved, we'd have them calendared and scheduled. Nobody seemed to want to do that, and so we were apparently at an impasse on that issue. From the plaintiff's perspective, those are the three issues with respect to discovery.
But
Thank you, Your Honor. Dan Heyman for AECom. Addressing the three issues, starting with the 30B notice, and we've presented, as requested by the court, our position in pretty good detail, generally into the specific requests. And I don't think it's accurate to say after we had our meet and confer, we were down to 9. We got a revised notice, and we did make some progress. Some there's agreed to be limited. We got the revised notice, I believe, last Thursday. As I told Christine, we would review and get back to her. She unilaterally said, here's the revised notice, we're now down to 9. But in any event, I think we're at about 13. But as we've indicated, Judge, first of all, this is the first deposition they want to take. Okay, so of a 30B, there's been no depositions, which is going to require us to educate someone on this project before the benefit of any depositions, including our former employees. All our employees on this project that happened 8 years ago are no longer with us. So, you know, it's likely, instead of being able to point to their deposition testimony, we're now gonna have to schedule meetings, et cetera. And some of these, as you've seen, just the sheer volume is impossible.
Hold on a minute. So you've indicated Stahl, Lachina, Wenzel, and Harvey, right?
I'm sorry, Stahl, Lanchina.
Stahl, Lanchina, Christie Wenzel, and Brad Harvey.
That's correct. There's been no, and they're no longer with the company.
Right.
And there's been no request yet for Wenzel, or Hartman. But we have been in contact with Stahl and Lanchina. They work for other companies now. And as I explained to plaintiff's counsel last week, I can't in good conscience ask these people to call in and schedule time off of their current jobs on a tentative basis with no idea if this deposition's happening. We're prepared to present those people. But if plaintiff insists that we have to have a 30B5, assuming we can agree on some categories, that's gonna take some time because we have an obligation to educate someone on this. And, you know, there's been, our client alone, I think, produced almost 500,000 pages of documents. We're getting close to 1 million pages of documents in this case. We're talking about incredible breadth, especially what they've asked for, and putting aside just the ones that are incredibly broad with respect to this project. We have 3 or 4 of the 12 that are in dispute. I have 13, but 12 or 13 that are in dispute that want us to put up a witness who has global knowledge of all the projects that AECOM has done, global knowledge, with respect to certain issues. And so that's just, I don't know how you'd even begin to do that. You know,
The issue relates to the fill, right?
Correct.
That's what we're talking about, the fill.
correct. There's fill on every project, Judge.
I know that.
So
The issue in this case, the main issue seems to be the fill.
Correct.
The shale.
Correct.
Okay. So,
So if the, but how are we about to, you know, find out, you know, from the scope of what they're asking for? It could be a project in California, it could be a project in Beijing, it could be, and how do we even begin?
okay, let's quit playing around. Let's take out the list
Okay.
of 1 through 29 and go through it. What's the first one?
First one, Your Honor, is AECOM's knowledge, evaluation, and decision-making regarding the suitability, risks, recommendation, and use of pyritic shale spoil excavated from the Northeast Ohio Regional Sewer District project as engineered fill supporting interior building slabs of the YMCA School District and Senior Center.
Okay, go ahead.
We've agreed to produce a witness.
I'm
on
sorry,
that that involves this project.
I'm trying to find your latest objection.
No, let's go, I'm looking at the original list of 31.
Okay,
That's what I have in front of you.
would you like, Your Honor, for me just to go over the ones that AECOM says they will not produce
Well, I'd like to
witnesses
see a
for?
copy of it, so I'm looking at it as you're,
Yeah,
all I
think
have
it-
is the original that was filed with these emails.
I think it would be helpful, Judge, if you had the amended notice
Judge,
and,
I do have a clean
I-
copy of the amended.
Yeah, I do
Okay.
as well.
and do you have our responses? Would you like our
This
responses
is-
too?
This is our responses.
Okay.
So that's the, what Christine said is the amended and your responses?
Yeah,
That's
I have
correct, Your
the
Honor.
amended, yes,
That's the
yeah.
current
that's okay.
status.
Okay. Thanks.
The court should have an electronic copy of this as well from our position that was submitted yesterday.
I did also, Your Honor, at Maria's request yesterday, provide her a red-lined version so you can see how they were changed from the first notice to the amended notice, and I can give you that if you think it's useful.
All right, well, number 1 on the amended list, there's an agreement.
Correct. So I will move, Your Honor, to number 2,
Okay.
which there is, AECOM has indicated in its latest objection that it cannot produce a witness. That is AECOM's knowledge and experience nationwide and globally with projects using shale or shale-containing materials as engineered fill regarding suitability, risks, recommendations, and use of shale or shale-containing materials as engineered fill for the project where AECOM has the noted knowledge and experience.
Okay.
And again, Your Honor, plaintiff's position is AECOM regularly markets and sells itself as a global leader with expertise in all of these areas. And in fact,
So what is it you're looking for?
I'm looking to know what they know and understand about using shale fill material on construction projects.
Judge, if I could put a little perspective on this. Every building in Northeast Ohio's got shale in the fill. And if you look at the expert reports, it is a very detailed analysis, and we don't have to get into it now. But the notion that there's a green light, red light on shale fill is just nonsense. I mean, we'd all be living in tents in Ohio if that was the case. There's shale everywhere. So this is so broad. This, I don't know how many tens of thousands of projects, and how do we even begin to do that? And they're all different because they all have geotechnical.
Is it your position that shale shouldn't be used as the fill? And shouldn't have been used as the fill in this project?
That's right.
Okay. What does the contract say?
The contract has the specification for engineered fill, does not permit the use of clay, which shale is specified as is classified.
So do you have
technical terms as
so I presume you're going to have an expert that says that this was the improper fill to be used to take out whatever was excavated.
Yes, Your Honor. And his expert says that, and everybody's expert says that.
Okay, so
That's not the issue. The issue is I believe I'm entitled to tell a story to the jury about why AECOM, knowing and understanding, being the global leaders in construction that they are, decided to propose to my client to use this material that is plainly and commonly understood as to be improper underneath the building.
But it wasn't permitted to be used, is what you're saying, by contract and by all the experts, right?
That's right.
Okay.
Not our expert, Your Honor.
Okay. Well.
And but that is the issue. And so it has nothing to do with our global knowledge.
I know it's the issue.
It has nothing to do with our global knowledge. And they did it, we may market ourselves that way, they didn't hire that services from us. We had no design or engineer, we were the construction manager. They hired the architect, who, like every project, has a geotechnical engineer that they hired, who tested this specific material and told us it was okay. So is there an issue?
Or didn't test it and say it was okay, one or the other?
They absolutely tested it.
Okay, and they say you didn't test it.
No, we did it.
But anyway, see, we can sit here from now until the summertime when it's scheduled for trial and talk about this shit, but what I'm interested in knowing is getting the depositions done, because the expert reports were to be filed June 2nd, I think it was, okay? And the remaining by September. Now that's been moved, done. Fact discovery was done. But apparently...
Oh, Your Honor, I believe at the regional case management conference, due to the case, there was no fact discovery.
I know there was no.
Yeah.
I
Correct,
presume
that
I presume that you wanted to do written discussion in advance of taking depositions.
That part was...
Okay, not depositions. So let's try to get off the ground and stop discussing, you know, I brought up the contract, so but I want to get the, so you think you should be able to have somebody who that has knowledge of and all the representations they've made. They made the represent.
They made it on their website, and they
Okay.
made it in the response to the
Okay.
request for proposal for this project, where they say, as a full-service
So
company.
so you you believe that it's proved that they hold themselves out as action?
That's right, Your Honor.
Okay.
I have no idea.
Who do they produce for something? How about the president of AECOM?
The president of AECOM's not gonna have knowledge of every,
Okay?
well, that's
I don't-
globally.
Listen,
The United States.
Oh, great.
your point is, they hold themselves to construction, okay? And because shale was used, either pursuant to the that's a bullshit claim that they made. Otherwise, all right, what's that really got to do with this? Isn't this a case of whether the use clay/shale? Isn't that the point?
Ultimately, but again, I think I'm entitled, and because I believe the facts are clear, including their geotechnical engineer that they consulted with. using this
Consulted with
material.
either during the project or after
During-
Guyama, or whatever, that guy.
I believe when I get to, they shouldn't have used this material. So, you know, the jury's going to question, Your Honor, why did they do that? And I think I'm entitled to tell the full story. And part of that story is that they didn't bother to either use their expertise that they promised us that they would use, and that I think is part of the standard of care that is an express provision in their contract, to use their expertise.
The contract either calls for them, allows them to use shale clay, or not use shale clay, right? The contract.
Your Honor, shale clay was not originally specified to be used. It came about as a change on the project due to the discovery of unsuitable soils during the site work.
I mean, is it unusual to find unsuitable soils in site work?
It is not unusual, Your Honor, and therefore the contract included not the type of material to be used, but a unit price. So AECOM was only able to charge our client by contractual agreement before they knew that they had to bring in 10,000 plus cubic yards of this stuff, that they were only going to charge $25 a cubic yard. They were limited to that by contract. Their subcontractor apparently had this, and when it bid the project, bid very low for that unit price, which probably helped them win that contract. And so they had to use something that wasn't going to eat into their profit margins. And so they used this shale. And I want to tell the jury about how AECOM fully well knows that it shouldn't have been used, but they disregarded that because they just cared about making as much money as they could.
So it was not prohibited by the contract?
Your Honor, it
Shale-
was prohibited by their contract.
Okay. You told me the only restriction was the unit price or whatever had to be used as the fill.
No, Your Honor, the specifications have a general specification for the types of material that are acceptable and unacceptable by their general classification. By their general classification, the material is unacceptable. Nevertheless, the construction manager recommended it, and the architect and its geotechnical consultant approved it.
Okay, I'm not gonna let you, 2 is out. 3.
Okay, 3 is AECOM's knowledge, expertise nationwide and globally regarding the known risks and consequences of using expansive material as engineered fill, including but not limited to AECOM's knowledge and experience regarding when unsuitable fill material must be sent or rejected or sent to a landfill.
Similar objection, Your Honor. I don't know how we even begin to present a witness on that.
Who hired ATC?
The architect TDA, we did not hold that contract. And by the way, ATC is the one who, in real time, when the decision was made about using this fill, tested it twice and reported the results. TDA reported to us that it was acceptable. But I don't want to get into all the merits like we've been going. I want to focus on this, Your Honor.
So do I, but I had that question because you keep saying we weren't the geotechnical engineer.
They didn't hire us for
on
geotechnical
the
service.
project.
Sorry, Your Honor, that's correct. And our contract expressly says we are not responsible for the architect's scope, which included the geotechnical engineer. So we may market ourselves that way, and we certainly have that capability because it's a big company, but they didn't hire us for that. They hired us for what's in our contract, which is to be the construction manager.
And so so whose job was it to provide the geotechnical engineer so that the specs could be drawn and the contract fulfilled?
I'm sorry, it was the architect hired the geotechnical engineer, who, like any project, started with the geotechnical engineering report before design's even done, talks about what kind of fill can be used, et cetera. Then, of course, we get the specifications, which is what we're bound to. But none of that we didn't have anything to do with developing those specs. That was the design professional and their geotechnical engineer. Is there an issue of fact as to whether or not we met the spec? Yes, that's what this case is. It's that simple, Your Honor. And all this other stuff about telling our story wants to distract from what happened here and why.
So who was responsible for determining what fill went back in the hole?
Your Honor, the construction the entire construction and design team. So the construction manager was
Who had by contract, who had the approval? When decisions are to be made such as this one, we're excavating however many cubic feet, what's going back in, whose job was it to approve or disapprove of that?
Your Honor, I believe it is both the architect's job and the construction manager's job.
That's what the contract says?
Yes, and the contract has a specific provision that says if the construction manager recommends a material or product that it warrants to the owner that that material is fit for the specific purpose.
Your Honor,
Your Honor, when there was a discussion about what fill to use, the architect did not propose shale or any other material. The construction manager proposed the shale material.
Okay. So going back to number one, that everybody agrees on.
correct.
Who's gonna be produced for that?
I don't have a body here, but because it's limited to this project, we can educate someone. It's going to be someone who wasn't on the project, most likely, because there's none left. But we, as we can do and have an obligation to do under Rule 30b-5, we'll educate someone
Okay.
as best
So
we can
as
with
to
the
the-
records. We'll try to put them in touch with the people who are on the project if we can, but they don't want.
As to the decision-making regarding the suitability,
It's all in the records, Judge, and we'll have someone that will have reviewed and educated themselves on the
okay,
records.
so somebody will have reviewed the suitability and the risks and the recommendation of the use of the shale?
That's correct, Your Honor, the spec section is very clear, by the way, when you have unsuitable soils, the architect in consultation.
I don't care about that, okay? You're gonna produce somebody that answers her questions about the suitability of this shale being used as the fill, correct?
Everything in here, the knowledge, evaluation.
Right, I'm just focusing on the
Okay,
shale.
yes, Your Honor.
Okay, and so there's somebody that kind of infers to me, there's somebody within AECOM that looked at the suitability of shale. Okay, and so she's gonna ask, well, what did you review? Who did you get this from? I got it from Joe Schmo.
That's correct,
She
Your
can
Honor.
go depose Joe Schmo.
You're correct, which is actually a third-party defendant, GLC, who was our site contractor. But, Your Honor, I mean, we did object to this, although we'll produce a witness, just to make it clear. We
I
didn't make the
thought we
decision.
agreed on number one.
We didn't make the decision, but we'll have someone who can talk about everyone who did and all the
I
records.
thought we agreed on number one.
Correct, Your Honor.
Okay, then what are you objecting to?
Well, I'm sorry, I thought you were asking who we were gonna produce for number one.
I was asking that, okay, but whoever you produce for number one is gonna be able to talk about the recommendation of and use of shale.
That was made by the architect, and it's.
I don't care who.
Okay, yes,
See,
yes,
so
Your
that's
Honor.
gonna point her in a
Yeah,
direction that it
yes.
was Joe Schmo, okay? And then she can go and depose that person, right?
Yes, Your Honor.
So what's the problem with that?
No problem with number one, Your Honor.
I know there's no problem with number one, but you wanna talk about their knowledge of, in their representation that they know all this stuff.
Yep.
And part of what you're gonna find out is their recommendation and use of shale. And that's gonna point you in a direction of somebody at AECOM or within AECOM or who AECOM consulted that says shale's good for this. So why isn't that enough? Why doesn't that give you the same thing you want by the worldwide investigation here?
I think, again, Your Honor, I mean, if you believe the interpretation of that is broad enough to encompass that, then I'm fine with that.
That's what I believe.
Okay. And we're in agreement that I can ask about those matters within
Well,
the
they've
scope of
already
number
agreed that
one.
you can ask about those matters.
Number one.
Right.
Correct, Your Honor.
Okay.
Not number two, which is out, and there's similar ones after it. We're not gonna have a witness who's gonna talk about our experience in every project that ever you show.
I just said that, we just
Okay.
covered that.
Okay, well, I think Plaintiff's counsel said as long as I can do that on number one. I just wanna be clear, Your Honor, thank you.
Okay,
Okay.
Your Honor, so just to move this along, I'm gonna agree to remove 2, I'll remove 3. 5. Okay, let's move on to a different issue. Number 6, AECom's knowledge, understanding, compliance, performance, and breaches of the contract with the plaintiff for the project that is the subject of this lawsuit. AECom has responded that it will only produce a witness who can authenticate the CM at-risk form executed by AECom. And their knowledge and understanding of that is contained in the plain language. Somebody that says, yeah, this is the contract. But
That's
not
our-
talk about what they did, didn't do, should have done. And just by the way, Your Honor, they asked me almost the exact same question for my witness.
Which we discussed our meet and confer, and I said, if you wanna narrow it, we will. I've asked for a meet and confer on their 30B5 because both parties have an obligation to conduct one, and I haven't had it yet.
I don't have any objections.
Okay, well, good, thank you.
I thought I said that at the
We'll
beginning.
expect dates then for those witnesses. Your Honor, knowledge and understanding is in this contract is thousands of pages, it's a construction contract. Compliance, performance, and breaches, again, are we gonna put a witness who's gonna talk about everything we did that's documented in 500,000 pages of records? Or are we gonna focus on what's at issue, which is number one, which we've agreed to do? So, it's not.
Well, part of what their complaint is, when they brought the first heaving of concrete or cracking in the walls, they said, well, you guys are warranting this work, so come and look at it, and according to the plaintiff, you said, well, we don't know nothing about nothing, everything's good.
Not accurate, Your Honor. There were years of the parties, and well after this project was done, well after punch list, where we were involved. Architect was driving that ship, by the way, which you would expect, because it's a geotech issue. But nonetheless, there are other specific categories in here with particularity, like what did you do to investigate, that we're agreeing. You know, warranty claims, we're agreeing. But this general, give us someone who can talk about everything you did on the contract and all our allegations of breach, is again just not within reasonable particularity required by the rules. It's basically the whole case. Put someone up who can testify about anything I want to ask on this case.
If it's limited to the issues in this case, I don't know why I wouldn't be able to ask about those things. And I don't know why you wouldn't be able to produce a witness to do that. We all know what the issues in the case are. I'm not going to ask about some obscure section of the contract that doesn't have anything to do with this case, of which there are many. I think we all know what the issues are.
So you're
in
talking
the
about
case.
number 6 as it relates to the fill and building envelope issues?
Yes, Your Honor.
That's, again, number one is the fill, which we talked about. There are specific things, to your point on investigation, as we go through this, I can point to them. We agree to that. If you tell us particularly what you want, we have the ability to prepare a witness. To prepare a witness on anything about this contract, and certainly we're not gonna prepare and present a witness who's gonna interpret the written contract and give some kind of analysis, is overly broad, and it doesn't meet the rule requirements of particularity. Some of these others do, and we've agreed to present a witness. But this is a catch-all about anything I want to ask, they better be ready for it. How do I prepare a witness for that?
As it relates to the fill and the building envelope, right?
Yes, Your Honor, and I can add those words if it, but
That would seem to satisfy Dan, wouldn't it?
Correct, Your Honor.
And just to be clear, Your Honor, I do think I'm entitled to question them on their understanding of what particular parts of the contract pertinent to those issues mean.
Under what basis? I mean, it's a written contract. It says what it says. That's for the lawyers and the court to determine.
Your Honor, they act in accordance with what they understand the contract to mean, so I think I'm entitled to
So
ask.
give me an example of that.
I'm entitled to ask him what he thinks it means when they warrant that they're recommending a material, and what he thinks recommending a material means. Because they're taking the position that they never recommended the material. Well, I'd like to know what their position is on that.
On whether they had an obligation to warrant the material?
Correct.
Or recommend the material?
To recommend the material and the warranty associated with that recommendation.
Whether we recommend the material
As one example.
is an issue of fact, which we keep going, is number
Well,
one.
so why can't she do fact discovery?
She's gonna ask a lay witness whether or not you satisfied this warranty obligation, or doesn't this warranty, again, a legal
Well,
argument what the
I
contract.
think she just said she's gonna ask whether it was your obligation to recommend or not recommend.
That's number one. We'll have a witness on that. But this, as written, number 6 is, you know, if we want to limit it to the fill and building envelope, that's okay. But to have a lay witness who's going to be interpreting contract provisions is not appropriate.
Well-
She could ask if we satisfied it, what we did. But that's what, I think she's made it clear what she wants to do.
I want to know what their understanding of that provision is, and others
Well,
that
they
relate to it.
either had an obligation to recommend, or they didn't have an obligation to recommend, right?
Well, I don't know, Your Honor, about the obligation, but
Under the contract.
What the contract says is that if they recommend, then they must provide this warranty. Our position is, in fact, they recommended it, and they provided the
So
warranty.
your hope is to get somebody up there to interpret the contract and say, yeah, it was our obligation to recommend?
No, Your Honor, I want to ask them what they understood that provision to mean,
Okay, for what though?
because they're taking a specific interpretation of that. And so I want to know what the company's position is on that interpretation. I know what the lawyers say, I want to hear what the witness says.
That is the company's position.
What did you say?
Thanks, but I'd
What
like
the
to
lo-
hear a
what the
witness
lawyer-
under oath cross-examined as to that position and not their lawyer.
So don't you want to find out from the fact witness whether ACOM recommended use of the shale? Isn't that the issue?
Yes, Your Honor.
So what difference if, where's the relevance of some guy saying, well, my understanding of this provision is that we were to recommend, or my understanding of this provision is we were not to recommend? What does it matter? The issue is whether they recommended or didn't recommend.
That's right, Your Honor, and there's a dispute about what recommending means. And so I think that I'm entitled to question him on what the company's understanding and position is
What
on that.
about what they actually did? What the fact that, establishing the fact, not establishing what their theory is of what this means or doesn't mean?
Yes, both, Your Honor.
Okay.
I
Well,
agree.
but why is one relevant? One is definitely relevant, one I'm not sure is relevant.
Well, Your Honor, here's how I understand their position to be based on what I've seen so far in the case and not having taken any depositions. Notwithstanding the fact that their project manager sent an email saying, you can use this material for this price that you
Okay?
are
So-
obligated to pay, that is not a recommendation.
Okay, so you're gonna depose that person, whoever wrote that email? And you're
I
gonna
am, Your
say-
Honor, but here's what I'm trying to avoid. They're gonna take the position, if it's convenient for them, that whatever he says doesn't bind the company because he's no longer an employee and he's
Well,
not
he
the
was at the
33.5.
time.
I understand.
Okay, so what does that matter that he's no longer?
Well,
You-
that's
you
why,
wouldn't- I mean, that would be a ridiculous position to take, wouldn't it? We're not responsible, even though he worked for us and said this,
Yes,
because he
Your
no longer works for us. That would be ridiculous,
Yes,
wouldn't
Your
it?
Honor, and again,
Okay.
number one is knowledge of hazardous decision-making regarding suitability
I
risk
know,
recommendation.
I know what number one says.
We're producing on
Okay,
that. That's the issue.
But you know who that person is that said you can use this material at this price to Great Lakes Crushing, right?
I know, Your Honor.
Because there's an email that says that.
I know based on that email. I don't know what communications happened internally at AECom to get to that email where they recommended the use of that material.
Okay, so don't you ask the guy who wrote that email, why did you say this? Where do you get that information from? Well, I get it from this guy over here. Well, then I'll go depose this guy over here.
Yes, Your Honor, I understand, but again, the reason that we do 30B5 corporate rep depositions is because they're technically the only ones who can bind the company to those statements. So if I then present their former employee as saying something, they can say, well, that is not our corporate representative, he cannot bind us to that position.
Well,
Made worse by the fact that they clearly fired him because he messed up his project.
We're certainly not gonna stand in front of a jury and say that, Your Honor, but we've agreed to produce that individual as well. But again, we're focused on the 30B5 and we'll produce someone who's going to basically parrot what he's going to say, if that's what they want.
Yeah, that's what
But
we want.
that, again, does not get into giving legal opinions on what a contract means, which is not relevant. That's for the lawyers in the court to determine.
I'm not asking anybody for their opinion in
Well,
this,
you-
I'm
you-
asking for their understanding,
Well, isn't that their opinion? Isn't it the understanding their opinion?
not necessarily.
Well, it certainly isn't a fact, is it?
It is,
This
it's a fact.
This thing means this.
It's a fact based on that individuals act based on their understanding
Well,
of things.
it's
And
their-
so I want to know what their understanding is.
And their understanding is gonna be what's written on the paper, Your Honor.
Well, that's what you say.
Well,
He can say that
Okay,
and
so
I can
so who would
cross-examine
this
him.
person be? Who you imagine this person would be?
Your Honor, I don't know. It could be one of, I don't know how many people who worked on this project, were responsible for this project,
I think
or
you-
somebody who wasn't, and that they
I-
educate and give them that
I certainly think you
information.
can depose somebody who has, with regard to the contract, as with regard to the contract issue of the fill in the envelope, their testimony on whether they complied with the terms of the contract or not.
Okay, so is the only issue then the word understanding? I'll take that out.
And if you, well, again, Your Honor, performance of the contract and breach, I mean, that is so broad. I mean,
What,
how do I?
I'm gonna go out on a limb here and say, if you produce somebody to talk about whether AECom complied with the terms of the contract as it relates to the fill and the building envelope, they're gonna say, of course we did.
Most likely, Your Honor.
Well, and then what are you gonna say? Well, are you,
Again, Your Honor, I have agreed that adding the word, limiting it to the issues in this case, which are the fill and the building envelope issue, is sufficient from my perspective. And further, I will eliminate the word understanding.
Your Honor, number 17.
They want to just say, yeah, this is the contract and nothing more. I don't think that's acceptable.
Your Honor, number 17 is any warranty claims for or relating to any water infiltration issues and floor slab issues for the project as the subject of this lawsuit would agree to produce a witness. When they describe in particularity factual issues that they want a person on, you agree to produce them. But these general, just to have someone talk about your performance under the contract is not the required reasonable particularity that the rules require. Same thing with the contract. They have number 18, AECom's contractual warranty obligations for the project that's subject to the lawsuit. We've agreed to produce. Okay, in the thousands, if not tens of thousands of pages of this contract, you now, with reasonable particularity, have told us what we have to prepare a witness on. You can do that. But these broad, just, catch-all So I can play a gotcha game
Okay,
with
so
an
you-
unprepared witness are inappropriate.
You have, of the 29, you have either 16 or 17 you've agreed to, right?
I believe that's
You
correct.
said 13 you don't, you said
That's
12 you
correct.
I thought it was 12 when I counted.
Okay, so let's do it this way. Tell me the 12 you've agreed to.
Oh,
The
so it should
16
be
of the 17
17
that you've
we've
agreed to.
Sure. Here.
1, 4, 6, 7,
Well, I don't think 6, based on this.
well, we
objection.
say, we had a qualifier, so, all right, so, 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, 20,
Okay.
22, 23, 25. I believe that's it.
And you have one more that you thought was agreed to?
No, Your Honor, I had mismarked it on my copy. I think that what Mr. Hayman said is accurate.
Okay, so 2 and 3 are out.
I think I also agreed to remove something else.
I think 5 was another,
5.
one of the national and global.
Yep.
Okay, so let's go to 14. Are you talking about written communication?
Any.
Huh?
I'm talking about any communications, Your Honor. Now, I understand nobody's going to know every conversation that anybody have. That's why the standard is whatever is reasonably available. But they're obligated to go and find out what communications there were that go beyond the scope of the documents. And if there's nothing available, then there's nothing available.
Your Honor, I don't know how we determine all representations that were made on this project at this point, other than written, which are going to be thousands, most likely. I've seen enough of them. And, you know, former employees who were prepared to present, and they can talk about what representations they made. But again, the breadth of this, I don't believe meets the requirement of the rule of reasonable particularity. If there were certain representations that you could identify for us that we could educate someone on, because that's what we have to do. Because the people who worked on this are no longer with the company, we can do that, but I don't know where to begin on this. I mean, do we give them, you know, tens of thousands of emails that have been produced in this case? Start going through, and I mean, it's unworkable. It's not reasonable particularity is required under the rules, and it's unduly burdensome. You know, again, the rules, not only 30B, but civil rules in general, does require that you weigh that. And if there's other means that do not, you know, require us to go through all of this, where you can depose the people who are on the project, you can ask them about their written communications, you can ask about their oral communications. But if you want us to educate a 30B5 witness on something as broad as this, it's a Herculean task, and we don't think it meets the balance that the rules require with respect to undue burden.
So you know who was working on this thing for ACOM, right? Working on this project?
I believe I know some of them.
Well, there was 4, you read them at the beginning of the of the
Were
day.
those the only 4 people from ACOM that were in the capacity as the construction manager on this contract?
That's correct, Your Honor, and one of the third-party defendants, Green Space, had some individuals, they were sub-consultant to us. And Plains Council has asked for 2 of them, and we've said, yes, we'll produce those 2 former witnesses, or excuse me, former employees, who were the ones who were having these, as everybody knows from the records, these communications.
Okay, so you know you're gonna depose those 4 people, I would assume.
I'm going to depose at least 2 of them presently. I haven't issued everybody who I'm going to depose, but Your Honor, I think the issue from our perspective is they're taking the position that is the owner's fault that this material went into the ground, among other things. And so I think I'm entitled to question a witness to get the company's knowledge of what you told the owner about this material.
The company knowledge is gone, Your Honor. We'll recreate it if we have to, if we
What do you mean
can.
the company knowledge is gone?
The employees
She-
who wrote the emails are no longer with us.
I know that. But
But we will educate someone to.
who were those individuals?
John.
No, what was their position within?
John LaCagna was the project manager on South High School. This contract is for 3 schools. South High School is what we're here for. Dave Stahl was the project executive. Christy Wenzel, I believe, was a engineer who basically just is, documenting stuff. And the other person, I don't recall exactly, but the other 2 that they haven't asked for really were not that involved, the records show, but they're free to explore if they want with them.
Okay. So if, let's say that whoever the first guy is,
John LaCagna.
LaCagna. Let's say
LaCagna, I'm sorry.
LaCagna says, yeah, I told Great Lakes Crushing to put that shitty shale in the ground. Okay, does that not bind the company? Is that your position?
Oh, Your Honor, if they want to say that if they want to agree that all of Mr. Lamatuna's statements bind the company, that's acceptable to me.
And if that, why wouldn't they bind the company
Well, I think, Your Honor,
as a construction?
as far as binding the company, the 30B5 deposition is, you're entitled to introduce it at trial as evidence, regardless of any witness availability. So that's what it is, which is why we have a lot of these things like legal understanding. This is a game of gotcha. Quite frankly, most of the stuff should be interrogatories or RFAs, but they're not, and they want us to put up a witness who's going to slip up and say, yeah, we agree that's what that contract interpretation means, and say, we've now bound the company and we're going to read that to the jury. It's all fine and good, Your Honor, but we have the right to insist that they meet the rules, which is why the rule requires reasonable particularity, because of the uniqueness of a 30B5 and the obligation for us to prepare someone and the fact that it's admissible evidence. We have the right and opportunity, number one, to insist that they have reasonable particularity balanced with undue burden and hardship, especially when there's other ways to get this evidence. Whether or not Mr. LaCagna binds the testimony, his testimony is what it is. He's going to either say the same thing at trial or they're going to impeach him. So again, there needs to be reasonable particularity so we can produce a witness. Now, normally, Your Honor, we'd have fact depositions, and when our 30B5 occurred, and they said, we want the representations, we're going to say, our witness is going to say, read Mr. LaCagna's deposition, pages 50 to 80. But they want this to go first, fine, but that's going to put a burden on us, and we need reasonable particularity so we can produce someone else to say,
All right, go to 19. Okay, so claims are made when things start going wrong. is there a record of who at ACOM investigated any warranty claims?
There is, Your Honor.
Who's that?
It's primarily Mr. Lakenia and Mr. Stahl. And in conjunction with the Green Space construction management people. But again, this is, you know, I believe, I have the year right, the school was completed in 2019. These issues, at least formally, were presented to us, I think, in 2021. If I have, you know, almost 2 years after the building was open. Mr. Stahl, at least Mr. Stahl, I don't remember, Mr. Lakenia, I believe he did too, re-engaged.
Were they gone at that point?
No,
The
they were
company?
not, Your Honor. They left shortly thereafter. We responded. There's other provisions in here where they say all notices and response to notice. We said, fine, and we'll produce someone on that, you know. But the investigation was those two individuals who, of course, they can depose them. They left both left in early 2022. So at that point, it was basically lawyers. Green Space, I believe, still had someone who was involved. They were meeting regularly with the architect, with the school. The architect was doing a whole bunch of analysis. They were doing floor scans and all this stuff. This went on for years, basically, at least 2 years, where the architect was driving that train and deciding what to do and they hired a consultant to do investigation, et cetera. So, you know, after 2022, when Mr. Lakenia and Mr. Stahl left, ACOM did have an individual who had nothing, when they requested a meeting, they had an individual who had nothing to do with the project, and he would go out. But then it really became the lawyers and their experts, so it's really getting into. But again, it's not like we had an investigation over a weekend. It is an incredibly broad topic with incredible breadth that went on for years before this lawsuit was filed.
Okay, so do you know who investigated these warranty claims?
I know Mr.
Lakenia?
Lakenia and Mr. Stahl was involved. I don't know Mr. Gatto, apparently, but I don't know beyond that. But again, Your Honor, I don't know why I wouldn't be able to ask about how they investigated the warranty claims that they breached. Because and if he wants to say, only Mr. Stahl and Mr. Lanokina know, that's fine. But then he should agree that their deposition testimony binds the company. And it's not overbroad, because if your position is that these are the only two guys that were involved, well, guess what? They can talk to whoever you want from the company, get their knowledge and understanding, and then testify on behalf of the company. It's not broad. That's what the case is about.
If Your Honor, if I may, if we were to do this like most of these proceed, and we had these categories, and we're going to take Mr. Lakenia's deposition, and this is very typical and usual, you'd say, okay, we're going to now do Mr. Lakenia's individual deposition, and we're going to now, but he's now going to be on categories 4 and 5. You can now depose him as a 30B5 witness. Well, they won't do that because they want us to have a 30B5 before we do Mr. Lakenia. Am I going to get Mr. Lakenia to sit for 2 depositions? I'll be, hard enough to get him to sit for 1, scheduling time off his job. So let's do them together if that's the case. It may very well that we can get him to be one of these, but we can't, if we want to insist on a 30B5 first, it's a problem. I mean, the 3 individuals that plaintiff said investigated are 3 individuals that have asked for their deposition. We'll get to Mr. Godwin in a minute, but we've agreed to produce him, but we have a clear understanding and ask the court's guidance for some of the various reasons we've talked about, global knowledge, et cetera. But they'll have the opportunity to depose those 3 people. But if they want a 30B5 on something this broad, it is going to take a long time to educate someone on that, rather than just ask the people who actually did it.
All right, 21. Isn't that the same? It's the same as 19, except for floor slab.
It's the same objection, Your Honor, but that's correct. It's basically, again, I'm talking about thousands of representations, probably.
All right, 24, go to 24.
Similar objection, Your Honor. We don't believe this is with reasonable particularity. You know, they've got all, whatever written internal communications there are, but again, you know, we're talking about hundreds of thousands of emails that have been produced in this case. And this is a very broad word that makes it difficult, if not impossible, to prepare a 30B5 witness, as opposed to deposing the people who are actually writing the communications.
Your Honor, if I might, it seems like what Mr. Haymond is saying is that if there are individuals who are involved, then companies are not obligated to produce witnesses pursuant to 30B5 notices. If that is in fact the law, then please cite that to me so that I can, you know, consider it, and will, you know, remove my thing. But that is absolutely not the law. There are individual fact witnesses and there are corporate representatives. Only corporate representatives bind the company. Again, if he wants to take the position that those individuals are their corporate representatives, that's fine. He can pick whoever he wants. It seems to me that relieving the burden that he's talking about is to use those people as his representative. Then he should just do that. He can pick whoever he wants, whether they work there or don't work there. It doesn't matter.
Even if I pick a Mr. Lacina or Mr. Stahl, or probably some of these categories would be several people, you know, they're gonna be our 30B5. Now I gotta have them prepared for more than just what they know. Fine. We have not taken the position that they're not entitled to take a 30B5. We have taken the position that they gotta meet the rule requirement that you specify with reasonable particularity so we can produce a witness. I think we've already seen, Judge, this 30B5, the way, with the scope that they're envisioning, is gonna take a week. I mean, there is undue burden and hardship to be balanced where you cannot say, produce a 30B5 witness to answer anything I wanna ask in this case. That's not the rule. And that's what they're trying to do with all of these broad categories. And as you see, just so they're sure, they just keep repeating a lot of them in different forms, so that, in essence, they have us educate a witness who can talk about anything to do with the case. That's not a proper 30B5 purpose.
All right, so you have, they're on 26 through 29 that are in dispute, correct?
Correct, Your Honor.
Okay. So I'll consider those that are still in dispute and rule on those. Okay, now what about this,
Thank you, Your Honor.
this guy that, this Gautam, what about Gautam?
We've agreed to produce him, Your Honor, for deposition. As I told plaintiff's counsel, I believe he's going to say, I have no recollection of ever working on this project or discussing with them during the project. That's fine if they want to do that. You know, there's about 6 in the sea of thousands. There's, I don't know, 5 or 6 emails where they're trying to schedule a meeting with him. But that's it. There's no record that it ever occurred or that he ever did it. But nonetheless, that's fine. They can depose him on that. But they've made it clear in their submissions to the court, but what they want to do is turn him into a geotechnical expert and start asking him all of his opinions about geotechnical items with respect to shale fill, which is irrelevant to whether or not we met the spec. And they're trying to turn him into a expert witness who's not been designated as such. And they know, because I've been out there with Christine and Mr. Gautam on at least 2 occasions, that after the lawsuit was filed, we as attorneys have used him as a consulting expert, which is absolutely privileged under the rules of the work product. So, you know, we will not let him testify to any of that privileged material. But if they want to take his deposition and hear him say, you know, and who knows, and maybe they'll throw something from him or he'll recall something, but to say that he doesn't have any recollection work on the project, we'll produce them. But we're not going to let them get expert opinions out of him, which again are not relevant to whether or not we met the specification. We were not the geotechnical engineer on this project.
Your Honor, I don't intend to depose him to seek his opinion. I want to know what he knows about this type of material and its use in similar applications.
How is
Why-
that?
And I'm not even gonna take the position that what he says is true or not.
But
But I wanna
so
know-
what does it matter what he thinks, what does it matter what he thinks is shale in these kind of projects? He either had some input on it, or he didn't.
Yeah, Your Honor, I think one of the reasons why it is very relevant is because, again, if they have institutional knowledge of these things, they represent and market themselves as bringing that institutional knowledge to all of their products, and in this specific case, made that representation to the client, it matters. And it matters because there's a consequential damages waiver in this contract, except if they acted with gross negligence or willful misconduct. And so if they're talking to a guy who knows something about this material and why it shouldn't be used, and he either didn't tell them or told them something that was accurate or told them something inaccurate, and they proceeded to use all of that stuff anyway, it goes to the issue of their gross negligence and willful misconduct.
Okay. Well, I guess what you're gonna have to do is tell me when you do your deposition at Gowden, okay? And I'll sit at my desk and stare at my phone and wait for it to ring,
Okay.
okay?
I don't intend, Your Honor, to ask him anything about work he's done, the Thompson Hine firm, anything he's communicated with them, or anything they've communicated with the dozens of in-house counsel they have on this case.
I'm just, I'm struggling to find out how, what he says other than as it relates to this project is relevant. But you can ask it, you can object, and then you can call me when you can't agree.
Thank you, Your Honor.
Okay, what about this ordering and scheduling? The first attempt to schedule depositions was December, mid-December?
Yes, Your Honor.
I guess the first question is why is that?
Your Honor, from the plaintiff's perspective, it was a large and substantial task for everyone to gather and produce the extraordinarily large quantity of documents in this case.
Okay.
It was a very big task for the parties to, or at least again speaking from the plaintiff's perspective, to get their experts' reports completed. And then, Your Honor, at least the plaintiff spent a substantial amount of time preparing for the mediation, which
I bet that went over like a lead balloon between the parties, right?
not even,
It was not successful, Your Honor. And
It was, sounds like it was a disaster.
yes.
What did it last, like
It's
5 minutes?
it's always a
No.
disaster if it's not successful, Your Honor.
You know, well, sometimes it's
It was
successful
2
and
days.
that parties narrow some issues and get closer together so that it can work eventually.
It was 2 days. And if I could just speak to that, a couple of issues. Document production has been an issue, and we've been trying to work with plaintiff's counsel on that with their production for a long time now. We had 40,000, I think, additional emails from the YMCA produced in November, right before the mediation. I think just this week, based on our meeting first to try to get the school district, because there's some glaring deficiencies, we got another roughly 30,000. So that's not been done. I've also been trying to get verified interrogatory responses on things as simple as itemized damages, which we don't have yet. But I do believe that the mediation, we didn't get the expert report until June. We didn't get the building envelope expert report until September. The parties did spend, I think, substantial time selecting a mediator during 2025 and scheduling it. I think we had our first call with him in August. There was a lot of meetings, and at the very first meeting with the mediator, there was a discussion about what do we need to do to get this case ready for a meaningful mediation. And there was a discussion about, do we do a bunch of depositions, or do we do things like get some expert reports in the mediation setting, because they're not due yet, but we still don't have the third-party defendant expert reports. so that we could do that. So all the parties, I think, did focus on the mediation, at least the latter part, once the plaintiff's expert reports were in September on that process. So I do think that that was a conscious decision that I can't speak for everyone, but that the parties collectively made was the best use of our time at that
I
point.
agree.
Okay. So besides your 30B5 and the individual, how many other individuals do you anticipate deposing?
Your Honor, thus far, I have noticed, I believe, 3 individuals, 2 former AECom employees. I believe the project manager for Great Lakes Crushing, which was the site contractor that brought in and used the fill, as well as the 30B5 of Great Lakes Crushing. Quite frankly, you know, I was waiting to see what information I got there and where else that was going to point me. Mr. Heyman has requested the deposition of Jeff Henderson from TDA.
So you've indicated about 6 different people right now, right now.
Presently, yes, that I have noticed.
Okay. Dan?
I believe we've asked for 8, and I've actually, because the party's not here, ATC's not in the case, but I've reached out to their counsel and asked for one of their employees. And quite frankly, Your Honor, I mean, mine include their experts, which is another issue I think that not just me but other parties want to discuss is the case schedule. And if we have a February report deadline, a March 1 summary judgment deadline, which we currently have, is why I asked for their experts. If there's a change to that, I mean, the experts can obviously wait. But those are the ones that I
So
determined are essential,
9 or so?
that I would like to have at least before the dispositive motion is due. There's gonna be a few more. I mean, I think the other parties, there'll probably be another dozen at least, I would think. Any other parties have feelings on that?
George?
Well,
You've been very patient.
representing the architect TDA, Mr. Heyman has noticed the deposition of main architect of TDA on this project. Christine did not notice any, so what TDA intends to do for depositions would really depend upon what's going on with plaintiff and AECom. But I mean, we produced an expert on behalf of TDA. ATC is not in the case, but is I'm in communication with ATC. Dan wants to take somebody from ATC. That's the, as much as I can tell you as to our plans on deposition.
Okay, so what kind of time frame are you all looking at? Collectively for just the fact that not the expert. You guys wanna schedule expansion, so
Frankly, the difficult we've had, and I'm not saying it's anyone's fault, with the number of council parties, we just try to like schedule mediation centers, try to schedule meetings. I almost feel like we need to designate what I suggested when I asked for a meeting for last week with everyone about, let's start talking about how we're going to schedule this. What I suggested is let's do it based on
So there's this, those are the procedural issues that I think you should.
When am I getting a response on the bifurcation?
Your Honor, the plaintiff is going to object to that, and I intend to file that by the opposition deadline date of Tuesday. What they're asking for is to make the plaintiff try
On the motion real quick that we got yesterday, we're gonna have to start over with the discovery if we're gonna have a consequential damage claim. I mean, I've got their discovery responses that aren't verified, that list general